Chief Justice Ralph Gantz. Why don't we first get a roll call of the, as I heard that Justice Lank had exited. She'll be back on momentarily. So among the justices have Justice Gaziano,
Lowy,
Bud,
Cipher, Baxter.
you have Justice Lank back? Not yet. Wait a moment for her. I just emailed her if someone could text her. While we're waiting for that.
Now joining.
Barbara Lank again.
Okay, you're back. Good.
I don't know what happened. I just got cut off. I'm sorry.
That's all right. On behalf of Mr. Weiner, who do we have?
Robert Cordy.
And on behalf of AG?
Assistant Attorney General Juliana Rice, Your Honor. With me are Ann Sturman and Kendra Kincher.
Okay. All right. I will go through the protocol with you. I believe Clerk Keneally has already described that. Clerk Keneally, do we have you on the line? I trust we do.
Yes, Chief.
Okay. The protocol is that Mr. Cordy will argue first. He will have in the ballpark with about 3 minutes to argue without interruption. If he wishes invite questions earlier, he of course may do so by simply so inviting. We will then be asking questions by seniority. Justice Lank first. I will be asking questions last. After I finish my questions, we'll give each of the justices a chance to ask follow-up questions if any of them wish. And of course, we'll do the same with regard to Ms. Rice. If anybody is on a landline and has a cell phone, please silence the cell phone. And if any of you are not speaking, please mute your phone so that we don't have any more background noise than is inevitable. And with that, Mr. Cordy, you may begin.
Thank you. What Cumberland Farms is attempting to do in its initiative petition is exactly what the framers of Article 48 feared special interests would do, combining in a single initiative what is popular with what is desired by their own selfish interests. The framers would call it log rolling, shielding those real interests behind unrelated shiny objects. A few more beer and wine stores in the neighborhood, more rigorous identification requirements to reduce underage purchases of alcohol, and a beefed up ABCC to enforce the alcohol laws. If there's a common purpose here, it is to enrich Cumberland Farms, increasing the number of statewide licenses they have from 7 to, say, 200. To do that, they need to remove or get around the cap on the statewide ownership of off-premises alcohol licenses. That statewide cap addresses important public policy concerns, the dangers of concentration of power in the liquor industry, preventing monopolies, indiscriminate price cutting, excessive advertising, and preserving the rights of small independent liquor dealers to do business. These policy concerns have been the subject of intense legislative debate and disagreements for more than 40 years. Not surprisingly, none of those debates have ever involved the community population-based limits on licenses relied upon and ratified by communities since the end of Prohibition, which the petition would also effectively eliminate. The concerns underlying the population-based limit are very important and completely unrelated to those underlying the statewide cap, and they directly affect the fabric and character of our communities and minimize the harm that flows from increased alcohol store density. Increased consumption, increased levels of assault and homicide, of child abuse and neglect, of self-inflicted and traffic injuries. So these two policy cornerstones, the statewide cap and the population-based community limits, are related only at the abstract level of alcohol regulation. And that is not sufficient. There is no unified statement of public policy here on which a voter can vote yes or no. The shiny objects used to make more attractive these unrelated provisions compound the constitutional problem. What, after all, do new identification rules have to to do with the statewide cap on the number of licenses that a company can own. Nothing. They are neither related to nor mutually dependent on each other. The petitioner and the Attorney General contend that such provisions can be permissibly combined, not because they are related to the other provisions, but because they address the potential consequences of adding an unlimited number of food store licenses to our communities. And they cite the Oberlease case. However, the decision in Oberlease undercuts that position. In Oberlease, the court went out of its way to point out that the inclusion of limitations on medical staff reductions, which was intended to address potential consequences of the new nurse-patient ratio requirement, which was the common purpose of that petition, were permissible only as applied to reductions triggered by the implementation of the new nurse ratio and not for any other reason. That, of course, is totally inconsistent with the identification provisions in this petition. Those provisions are not limited to addressing the potential consequences triggered by the new food store licenses, but are to apply, with a few exceptions, wineries, to all off-premises alcohol beverage licensees, which are now governed by the Safe Harbor Law, including the thousands who are currently licensed under Chapter 138. Again, having nothing to do with the statewide ownership cap. Similarly, the funding and staff ratio provisions for the ABCC, by their very terms, direct the ABCC to expend the money and use the staff not only for implementing the provisions of the initiative petition, but also for the ongoing administration and enforcement of the alcohol laws generally. Again, inconsistent with Oberle's limit on including unrelated provisions in anticipation of the likely consequences. In sum, if but one of the included provisions is not related to nor mutually dependent on the others, there is no unified statement of public policy, and the petition fails the Article 48 requirement. And that is plainly the case here. Thank you.
All right, I'll turn to Justice Link and ask if you have any questions. Link? They need to unmute.
Oh my goodness, I'm sorry. I did what you said. I muted myself. I just can't unmute myself, it seems to. Anyway, I wanted to focus on the relatedness issues to begin with, and to wonder, Mr. Corey, if you were using the statement of purposes of the Attorney General or the one of the voters seeking the initiative petition in your analysis. The one put forth by the Attorney General, of course, is to lift restrictions on the number and allocation of licenses. And, of course, the one put forth by the voters seeking the initiative petition is to establish and implement a system enhancing the discretion of licensing authorities to grant off-premises alcohol beverages. I'm wondering which one you're using.
Well, it is interesting that there are two different views of, in fact, what the relatedness is. The AG's common purpose, which is to lift restrictions on the number and allocation of licenses for the retail sales of alcoholic beverages off premises, actually speaks volumes. It does two things. It talks about lifting the restriction on the number. We're talking about community-based population limits, which is a very important policy, and the allocation, which is an entirely different policy, the statewide ownership caps. So it is talking about two very different public policies implicated in the same petition.
And you say that's impermissible?
Well, these are unrelated policies.
Well, why is it not? Policies can be unrelated themselves, can't they? In service of a common purpose.
I'm sorry, I can't.
I'm sorry. Can't there be a common purpose notwithstanding the unrelated policies?
Well, what's the common purpose? She says the common purpose is to lift the restriction on the number and allocation of licenses. Well, those implicate two very different public policies on which a voter could have very different views, and that's the problem. The statewide cap has nothing to do with the population limits that communities live with and have prohibition.
Okay, and the next thing is I'd like to turn to the specific appropriations argument that you make. I'm hoping you'll explain to me what appropriations means under the framers' intention.
Yeah.
What I'm getting at is it seems to me that there's somehow an ambiguity here, where is it to keep money in control of the legislature or to keep the budget process in control of the legislature? I'm not sure which it was. Or is it both of them?
Well, I'm having a very difficult time hearing. I'm sorry.
I'm sorry. I'm very sorry about this. Let me see if I can. Is that better? I'll just put it out.
Much better.
Much better? Okay. What I wanted to get to was the specific appropriations argument that you make, and figuring out what the original purpose of the framers was, because it seems to me maybe there's a tension here between was it keeping money in control of the legislature or keeping the budget process in control of the legislature. I'm wondering if you could comment on that.
Well, this is a particularly interesting statute in the sense that it takes a stream of revenue that has always gone directly into the general fund for the General Appropriations Act, and which is estimated to be between $90 and $100 million a year, and designates it into a very specific fund with very specific purposes to be spent by a very specific agency, and in that sense removes the fund of the monies, that stream that always went into the general fund, removes it into a special fund. Now, of course, the spending out of that special fund will be subject to appropriation. The legislature can decide not to spend all of the money, $100 million, that's in the fund, at once. They can decide which ABCC functions ought to get which amounts of money. Of course, that's the appropriation process. But the taking of the fund and really putting it aside and taking it out of what I think is out of the legislature's ability to say, oh, never mind, we're just going to use it for other things, is an important factor here and somewhat unique. The other piece of this, which is, oh, never mind, I'm starting to sort of repeat myself. But the Bates case, which is particularly interesting and has never really been applied quite into a situation like this, which says once there is an initiative petition that has passed, the legislature must carry it into effect or repeal it. And carrying it into effect means they must appropriate the money to carry it into effect. Well, okay, if that's the case, they must put the money into the fund and use it for the specified purposes. So to that extent, we think it's an appropriation that would violate Article 48.
Okay, thanks.
Situation. Sorry.
Any further questions, Justice Lang?
No, that's it for now.
Justice Gaziano.
Thank you. Mr. Corey, as far as that, to your last subject on specific appropriations, the legislature, of course, can decide how much the ABCC needs for their various functions, including enforcement. If you were to invalidate this on the grounds you request on the subject to appropriations, would we have to overrule Mazzoni in the AIM case?
Well, I don't think so. I don't think so. Subject to appropriation, these are not magic words that fix every conceivable problem. Two things. First of all, this is a different funding stream. It's very different than those other cases. And secondly, the Bates case, which really puts the legislature in the position of having to carry out the purposes of the petition or repealing it, and that means having to fund the petition, and where the petition itself includes a very specific set-aside of general funds with very specific purposes. I think this creates, or at least presents, a very different fact scenario.
Thank you. That's all the questions I have.
Justice Lowy.
Yes, I ask you about Hensley versus the Attorney General, and I recognize that you've distinguished that case by addressing as an industry that's been, the alcohol industry has been regulated since after Prohibition, and that the legal marijuana industry was new. However, if we look at the purpose of this petition as loosening restrictions on who can sell alcohol, certain types of alcohol, and where it might be sold. And we view the purpose as an overall loosening, and then the ID and technology provisions and the funding provisions, as you said, address the consequences of that. It seems like this petition is doing a heck of a lot less than Hensley did. Could you address that, please?
Sure. Well, in addition, of course, to the things that you've mentioned, eliminating the statewide cap on ownership is a really big and separate deal that's in here. But Hensley, the Attorney General in her brief describes the petition in Hensley as one which comprehensively regulated all aspects of a new industry, the commercial sale of marijuana in Massachusetts. Of course, the growing and selling of marijuana wasn't really a new industry. It had been illegal for about 100 years and often run by organized criminal enterprises. So it's not surprising that from the perspective of a voter, the voter would, a reasonable voter would want to know, before deciding about legalizing this whole illegal business, would want to know how it will be regulated and controlled. That makes perfect sense. So to the extent that there was an awful lot of, a large number of provisions specifying how it would be regulated, how it would be controlled, those were directly related and necessary for the voters to decide yes or no. And I think that's what distinguishes that case. This is an industry which has almost 100 years of law and structure that are designed to protect and ensure a whole range of different basic interests related to alcohol. And so that I think that does make a difference. And when you're trying to sort of change two unrelated pieces, and then add a few other little different changes to it all, they've got to be related in some way.
So
they have to do with alcohol.
So increasing and then eventually eliminating the restrictions on the number of licenses one entity could have, and then also making beer and wine available in food and grocery stores, that have a relatedness of trying to make it more available to the consumer to be able to purchase alcohol. I know you say that's one of the effects of that. Aren't they related?
Well, creating a new beer and wine license for food stores in communities has nothing to do at all with how many of them can be owned. The statewide cap on the number of licenses. Now, what this petition does, of course, is it creates this new license and says, oh, by the way, it's not governed by any caps at all, but we are also going to eliminate the statewide cap on off-premises license ownership. What has that got to do with which grocery stores are going to get licenses in their communities? There are thousands of
As significant as that is, though, I mean, in Hensley, we're dealing with licensing and regulating the entire industry and dealing with medical marijuana centers and legalizing marijuana all, and I'm not listing everything involved, all in one petition. And here you're talking about differences in the regulations within an industry, but not higher regulation in the industry. Hensley, do we need to rely on your point that a new industry as opposed to one that's been regulated since Prohibition? Is that the key distinction?
Well, I think the distinction is akin to that, but what would a voter want? What would a voter need to know in order to make a vote on yes or no? On Hensley, we are legalizing the marijuana industry, one that's run by organized criminal enterprises for 100 years. Wouldn't a voter want to know, how is this going to be regulated? How is this going to be controlled? That's very different than what we have here. What is a voter might wants a few more beer and wine stores, or want better identification procedures to keep underage purchases down, but would also not want a Costco or one of these huge international operations to come in and basically run the liquor industry by gathering up hundreds of licenses and exceeding the statewide cap, which is something that has been critically important to the regulatory process and debated for decades by the legislature. So that's the difference, I think.
Thank you. That's all I have.
Justice Budd.
Hi, good morning. Just along the lines of Justice Lowy's questions, isn't this just about how broadly we read related subjects? It seems to me that you could always say two things are not related, depending on how narrowly you define related, right? And two people could disagree about whether within a general area, two subjects within that area are related or not, as compared to whether two completely unrelated areas have related subjects. Is that fair to say? This is what we're trying to figure out, how broadly to read related subjects here. Is that fair?
No, I think that's right. There's not a bright line rule here. You have to sort of get under the hood a little bit. And if you look at these individual pieces, are they related in the sense that they all relate to alcohol? Yes. And they all relate to alcohol sales? Yes. But there are very different and important public policies bases behind each of these that are different.
Understood. But what I'm saying, and just what I guess I'm trying to get at is, what evidence do we have that we should take your view, which is a narrow view, that we should be looking not just at the subject matter, but within that subject, we should be parsing whether the individual items within that general topic, that general subject here, alcohol sales, need to be parsed any further. Where do I look for that evidence?
Well, I think it might be interesting, of course. I don't know if you had a chance to look at some of the amici, but if you look at how these issues have been dealt with separately and differently over the last 80 years, or certainly intensely over the last 45, you can see how the debates are very different. Yes, this is all related to alcohol, but what goes on in a community and how many licenses a community can issue based on their population and worries about impact, particularly on low-income communities. The density is very, very critical. If you look at that compared to the statewide cap, involve a whole set of different issues. Who who's going to be able to dominate? Will somebody be able, will a Costco or a Total Wines or somebody be able to come in and literally dominate the whole alcohol field?
And I understand there are policy reasons for and against, I guess, the question that they're looking to put on the ballot, and I understand that, and that can be debated. But what I'm saying is there any case law I can look at to say, oh, okay, this is how broad I should consider related subjects, what that actually means?
There are a lot of cases out there that touch on it, but always in the context of specifics. If you take Carney, for example, the Attorney General concluded that, the various pieces of Carney all related to promoting more humane treatment of dogs. Mm-hmm. That's what they were related to. But the court said, well, yeah, that's a very interesting and nice common purpose, but parimutuel dog racing and neglect and abuse of dogs under the criminal law are two really different things. Yeah, they all involve dogs and the treatment of dogs, but they're two different things, and they raise different issues.
Just remind me, did they both have to do with dog racing? No.
Did the what?
Did they both have to do with dog racing, or was it?
No, with dogs.
Yeah. Okay. All right. Yeah. So again, you can read it broadly or not. It just depends on what you're trying to accomplish, right?
Right. I mean, the Gray case is another example where the petition was, on the one hand, to sort of end the Common Core standards, and on the other, to release the comprehensive assessments every year with respect to comprehensive test assessments every year. And the court said, yeah, they're both related to education. They're both controversial public issues in the domain of elementary and secondary education, but not enough to make them related. There's no unified statement of public policy there. And I think the same can be said here. There's no uniform statement of public policy. Some people might want more beer stores. Some people might want not more beer stores, but better identification rules. Others might not want to see the whole industry dominated by Costco. So there are really different issues, and there's no unified policy here embodied therein. That's what I would say.
Okay, thank you.
Thank you.
Justice Seifer.
Thank you. Excuse me. My question involves, I've got this image now of Costco stomping in here and taking everything over. But the licensing would still be controlled by the state and the municipalities, would still have discretion to limit them?
Well, no, not
no discretion?
No. There are two pieces here. The total statewide, the statewide cap ownership means that Costco can only own X number of licenses. Total Wine can only own Y number of licenses. At the individual community level, well, I should say this, there's actually two caps at issue here. They're both dealt with in Section 15. One is statewide cap. You can only own so many of these outlets statewide. And the other is a local ownership cap, in addition to the number of licenses that a community can actually award.
Right, but just because you take off the cap does not mean that the state or the municipality is going to automatically just let everybody have whatever they want.
That's true, for sure, but it changes the dynamic, because now we're talking about arbitrary and capricious, and every case is going to involve, there's no limits anymore, so you can't say, no. The legislature has decided on a limit, you can't have any more. It's, well, why can't we have any more? The law doesn't say we can't, we're good, we're a big dealer, why can't we have any more? Is your decision arbitrary and capricious? I mean, then you get into a whole series of sort of legal battles about the issuances of licenses generally, both at the local level and then, of course, the state doesn't really issue licenses. It's all done at the local level.
Through the board. Yeah. One other question, and that is, you said in your brief that a voter would be surprised to learn that it impacts the sale of spirit in liquor stores, including at the point of sale. And my question is, if you look at the Attorney General's summary, and it would be the 4th paragraph, the proposed law would also change the statewide limits on the number of licenses to the sale of alcoholic beverages. If you just inserted including spirit, wouldn't that resolve your problem?
Well, it would make it more accurate. Yeah, well, I mean, the way this sort of deals with the stores that sell spirits as well as beer and wine for some purposes and not for others is different and complicated. But that's sort of the nature of the beast. That might clarify that, although I don't think that changed anything.
I have no further. Thank you.
Justice Kafker.
My questions are follow-ups on Justice Lowy's. So I'm not sure I follow the distinction when we're dealing with a pre-existing regulation and a new regulation, the marijuana versus the alcohol. Can't the public decide we're going to do a whole new regime of alcohol regulation and put it into a ballot initiative?
Well, surely the legislature can do that.
The public can't do the same thing. They can't say, okay, I want to totally deregulate alcohol. I want to deregulate the number of licenses. I'm going to spread it far and wide. And that's going to create some ripple effects. I'll regulate the ripple effects, but I don't like a regulated industry. I want to have a deregulated one, and I'll deal with the consequences. They can't do that?
Well, I don't...
In an initiative?
So the question would be, the petition would be, the alcohol industry is hereby deregulated. Anybody can sell whatever they want, and whatever.
Well, the public thing. I don't like just packed stores can sell liquor. I want to ban who can do it much further, because I want the public to be able to buy in any grocery store or Costco or Walmart, so that you don't have to go to a packed store. So we do one-stop shopping. And I understand that opens us up some, and I'll allow you to require, a particular kind of license to look at that. And I also know that the ABCC needs to be expanded because we're going to have many more sales. We're going to have many more places, and the existing number of people can't monitor all these stores. They can't do that because it seems like it's a coherent policy. It may not be a good one, but isn't it coherent?
Well, not exactly. I mean, the way you describe it may be coherent, but if you think of the statewide cap on the number of licenses that a company can own and why that's there and its history, you see that there are a whole series of public policy concerns that are dealt with in that respect. You could
I'm not saying this is wise. I'm just saying it's changing. Go ahead. Sorry, I didn't mean to cut you off.
No, that's okay. I'm cutting you off as well. This is a little complicated. But the other issue in this case, of course, is at the local level, how many licenses can the local communities hand out? Now, if you want to say, we would like to deregulate the licensing at the local level and allow any grocery store to sell anything it wants, that actually has nothing to do, that may really affect the community, and there may be a lot of good reasons people would want it or not want it, but that has nothing to do with the statewide cap on ownership, the number of stores one can own, which is a very different set of issues. So that's all I'm saying.
I understand there are existing, vested interests and also existing balancing that was done out there, but I'm just wondering why you can't recreate, why an initiative can't say, I don't like the system, I want to fundamentally change the system, and I'm going to do that and create what I consider a better system. It may not be, we may all disagree about that, but that's what the public gets to vote on.
Sure. The question is whether it's a unified statement of public policy on which a voter could vote yes or no. And what I'm saying is there are lots of unrelated pieces here, except to the extent they're related to alcohol, that a voter might feel one way about one piece, another way about another piece. There's no unified policy here. Not a unified public policy on which a voter could say yes or no.
Doesn't it go further? It's not just about alcohol, but it's about basically making alcohol available in many more places with less regulation. We're not going to give people control over the licenses. We're going to basically turn this into more of a free for all, and more stores can sell it. And there aren't going to be caps there on this.
On the number of licenses that that a company can own.
Right. Period. Yeah.
Period. No ownership cap, no statewide ownership cap, and anyone can sell the stuff.
Right. I'm not saying this is good policy, but isn't it a coherent one? Yeah.
Well, but you need to get, again, you sort of need to get under the hood. As you know, there was a initiative petition, I think 205, 206, if I've got that right, to create a new license of wine in food stores, which went down to defeat. This is sort of that broadened and with a lot of other little things thrown in to make it more attractive, which is what's going on here. But the answer is the subjects themselves have to be related more than just it's all about alcohol. And Hensley is so different because you're creating a new industry, one that has been dominated by criminal organizations. And the notion of a voter needing to know, in order to vote yes or no, what the policy is going to be concerning how this is going to be regulated and controlled is really important. And one can see that. That's not really what's going on here.
Thank you. That's all I have.
Mm-hmm. Chief Justice Gantz, I'm going to give you an alternative initiative, so give me a moment before you interrupt or the question. Because I agree this is complicated because there are can't see any body language. But imagine that the initiative said, this is an initiative to allow people to purchase wine and beer at food stores. So when they go to Stop and Shop or Cumberland Farms, pick up their groceries, they can also pick up beer and wine. And because that means that when you check out, you're going to be checking out groceries and everything else, we need additional security. So if you're going to be buying beer and wine, we're going to require the people at the cashier's office at the cashier's desk to make sure that they see an ID regardless of your age. That's going to be a requirement given that you're checking out more than just beer and wine, but could be checking out many other things. And that's going to open up a lot of places to sell beer and wine, and we're not going to limit the number of Stop and Shops or the number of Star Markets around the state. So we need to drop the cap on the sale of beer and wine. And because this is going to be generating that many more establishments, we're going to put the money aside that is obtained from the raising of beer, from the expansion of beer and wine sales to these supermarkets and other food shops, and that money is going to go into a special fund, and that money is going to be devoted to additional enforcement by the ABCC. Would that legislation, in your view, be sufficiently related to pass muster?
Well, in several respects, yes, because you're creating a new license you're going to bring in a lot of new licensees, grocery stores now. So the notion that you would want to have certainty with respect to ID checks with regard to those new licensees that are coming in makes perfect sense. The next level of, and we want to make sure that Stop and Shop can have as many of these licenses as they want across the state. One might say, well, okay, sure, but what is the policy implicated by that? And if you look again at the history of how that issue has been dealt with back and forth and extensively at the legislative level, what are the issues involved there? They are enormous and very significant. And so to say, a new food license, because we want more beer stores and wine stores around, we want to be able to buy it in different places. But the statewide cap, but we are concerned that no one comes in and buys 200 licenses and then runs the whole show and monopolizes it and engages in the conduct that the statewide cap is designed to ensure doesn't get out of control. I mean, those are two very different things, and I think the issue would be raised, and what does the voter need to know? Is there a unified statement of public policy here that relates both to more stores selling it and the statewide cap? That would be the question.
Now, the proposed initiative goes beyond my hypo, in that it would permit, say, Total Wine to be able to own as many places as it can in the Commonwealth, selling not just beer and wine, but liquor, and it would require the package store to require me to show ID, even though despite my youthful good looks, it's pretty clear I'm 21, and it would take all the money, including all the money from excise taxes from package stores, and put it into this particular fund. So is your argument that this initiative is essentially have provisions which are needlessly unrelated? Is there some argument that you're suggesting that we should look not only as to the overall initiative, but whether or not it is needlessly goes beyond the scope of what would be necessary to essentially ask the question, do you want to be able to allow food stores to sell beer and wine?
Well, I mean, things can be needlessly added. But if you add something that involves another public policy issue, you've got to think a little bit about the perspective from the voter. Are they going to be able to, is there a unified statement of public policy here that they're going to be able to vote yes or no on? Do they want more local stores with beer, wine, and other things? On the one hand, are they concerned at all, or do they have any sense of what the marketplace might look if, in fact, statewide cap eliminated, which has nothing to do, by the way, with the local population limits, the number of stores that a community can agree should be licensed. You really have to get under the hood and look at the operation of these things to determine whether they're sufficiently related under Article 48. There's no bright line rule here.
All right, I have no further questions. Is there any justice who has any further?
I have one more.
Yes, Justice.
I'll get back to the appropriations issue. Mr. Cody, can you hear me?
Yes, I can.
Okay, good. I'm just curious. I want to make sure I understand it. Now, do you say there's a separate fund that's going to be created, according to the initiative petition, would be under the control of the legislature or not?
Under the control of the legislature in the sense that it would appropriate money out of the fund.
Right.
Right.
But it would knock the heck out of the budget process, but not out of keeping money in the control of the legislature, huh?
Correct.
Okay. Got it. Thank you.
Any further questions?
I have one last question for Mr. Cordy. The language in Bates, it says a specific appropriation may not be made by way of initiative, and the insertion of the word subject to appropriation excludes any possibility that the initiative is an impermissible specific appropriation. Do we have to correct that to adopt your interpretation?
No, I don't think so. I mean, the Bates case, it basically said the insertion of the term subject to appropriation in the Clean Elections Law did not relieve the legislature of its constitutional duty to, in fact, make appropriations to fund the Clean Elections Fund. Either they had to do that or they had to repeal it. So even though it had that language in there, once enacted, the legislature still has an obligation to appropriate money to fund the initiative, or they can repeal it.
But that's
what Bates says.
But that's the second part of what they did. They assume that if you have the specific appropriation language, that you don't, if it's subject to appropriation, it's not a specific appropriation. They sort of assumed that is the first step, and then they said, well, okay, if it didn't have this language, then they sort of went from there. But they kind of assumed the issue we're confronted with, which is when you have the subject to appropriation language, it's not a specific appropriation, right?
That's correct. It's not a specific appropriation, but the legislature is required to implement the intention of the initiative petition, and here the intention is that these funds be segregated and spent on a very specific set of purposes. So the legislature still retains the power to say, okay, there's $100 million in here. We're going to appropriate $5 million of that for the ABCC, and these are the functions we're going to fund. But it can't then say, but we're going to take the rest of the money out of the fund and spend it entirely differently, because that would be exactly contrary to the intention of the initiative petition. That's sort of the argument. Okay. And Bates says if you either repeal it or you have to adequately carry it out. The unrelated issue is in some respects a clearer issue than, believe it or not, than the specific appropriation.
Any further questions? And hearing none, Mr. Cordy, thank you.
Thank you.
Thank you, Your Honor. Good morning, and may it please the Court. The proposed law would restructure the Massachusetts retail liquor market to make beer and wine more widely available at neighborhood outlets customers might be visiting anyway, like grocery stores and convenience stores. It would do this by lifting two numerical caps, one that restricts the number of food stores and may be licensed for alcohol sales in any single city or town, and the other restricting the number of licenses that one company may hold statewide. The other provisions would address consequences of this increased alcohol availability by imposing age verification procedures and ensuring funding for adequate inspection and regulation of the additional liquor outlets. Mr. Cordy in his presentation conceded that there is a common purpose among these provisions, and that common purpose was to enrich Cumberland Farms. To enrich Cumberland Farms and similarly situated companies, such as chain grocery stores in Massachusetts. They are a different business sector than the independent package stores that have participated in this litigation through filing amicus briefs, but they are also a different business sector than Total Wine and Costco. Costco as a warehouse club would be specifically excluded from this initiative petition under the definition of food stores that is incorporated into the proposed law. And Total Wine would not be eligible, as it is not a food store, for applying for this new kind of license. The Massachusetts Liquor Control Act was adopted in 1933 after the end of Prohibition and is generally structured the same way as it was when municipal license quota systems were implemented in the 1960s and 1970s. The petition sponsors may view this law as antiquated and non-responsive to modern consumer preferences. And updating the law as proposed may benefit some businesses and disadvantage others, and may have community effects viewed by some as undesirable. But it is not the role of the Attorney General to search for reasons to reject a petition on the basis of policy disagreements. Article 48 allows proposed laws to contain multiple subjects. It requires only that those subjects be related. As this court has noted, at some high level of abstraction, any two legal provisions may be said to be related. The converse is also true. Using a small enough lens, no two legal provisions could ever be said to be related. If you dismantle any multi-part measure and examine each part separately, it's easy to overemphasize distinctions among them. If those distinctions demanded division of this measure into 4 or more separate ballot questions, each proposing a separate change in the law, it would be extremely confusing and burdensome to voters, expensive to propose, difficult to administer, and likely to yield unworkable or unintended legal consequences. Questions didn't all pass or didn't all fail. As long as the common purpose of a proposed law is of a reasonable scope and all provisions of the law implement that common purpose, it's appropriate for the ballot. Turning briefly to specific appropriations, this court has never held that a proposed law may not direct funds to be used for a particular purpose, as long as the ultimate spending discretion remains with the legislature. And this court has specifically noted that setting aside funds for a specific purpose is not an appropriation. This court has noted that it is difficult to imagine how a measure which states that it is subject to appropriation, as this one does, could have been intended to be an appropriation in and of itself. The question is, would the legislature be powerless to appropriate money from the specified sources to any other use? And the answer is no. If this court were to accept the plaintiff's view that initiated laws may not redirect existing revenue, that would dramatically restrict the scope of citizen lawmaking. Noting that my 3 minutes have elapsed, I'll invite any questions the justices may have.
Thank you. Justice Link?
I want to go back to the appropriation issue. I'm really kind of stuck on it. I would like to know your view on the. Can you hear me, by the way?
Yes, Your Honor. Thank you.
Okay. I'd like to know what your view is as to what the original purpose of the framers was when enacting the specific appropriations requirement. Was it to keep money in control of the legislature, or to keep the budget process in control of the legislature?
I would say it's both, Your Honor. As we know, the framers, at the same time where they were debating what became Amendment Article 48, they were also discussing the implementation of a unified budgetary system that became Amendment Article 63, adopted at the same election. So it was their concern that initiated petitions would not be able to carve out permanently and remove from legislative discretion any funds. But at the same time, there was a robust debate on whether citizens ought to be allowed to propose laws that would cost money to implement. And after that robust debate, the framers concluded that they were not going to reduce the initiative petition procedure to one of merely resolutions or toothless ideas, but that in fact the voters should be allowed to implement laws that may cost money to enact.
Okay, but wouldn't you say that this initiative petition would disrupt the legislative control of the budget, even though it would not prohibit them from spending from appropriating funds?
I would not, Your Honor, because the provision would require that money be set aside in a particular fund. This court has held in Mazzoni and in other cases that is not an excluded specific appropriation, and that money would not be permanently removed from the budgetary process. In the two cases in which this court has concluded that proposed measures should have been excluded from the initiative petition process as specific appropriations, the 1937 opinion of the Justice's case and the Slama case in 1988. What was important to the court in both of those situations was the fact that the legislature would have been powerless to amend the subject fund, to appropriate the subject funds for any other use. In this case, the legislature is granted the discretion through the inclusion of the subject to appropriation language to appropriate the funds as it sees fit and appropriate leftover funds in that specialized fund for any other use. So I would say no. It would not disrupt the budget process.
I wouldn't. Okay. So Mr. Cordy's view of Bates then is incorrect? That the legislature would not be required in some fashion to do the will of the bidder, to do the bidding of the voters in connection with appropriating funds for a specific purpose?
Excuse me, Your Honor. I agree with Mr. Cordy's representation of Bates to the extent he states that Article 48 requires the legislature to either fund or repeal any law enacted through an initiative petition. But Bates was decided 10 years after AIM and Gilligan that have remained undisturbed to this day, stating that it is not a measure cannot be an excluded specific appropriation if, in fact, the legislature's spending power remains subject to appropriation. The situation in Bates was, of course, not a question of whether the proposed law should have been certified. The proposed law had already been certified and enacted. The court was wrestling with what that enacted law required the legislature to do. And upon concluding that the inclusion of the words subject to appropriation in the Clean Elections Law were not required, had been added solely for the purpose of avoiding a challenge to the initiative petition on a specific appropriation grounds, the court measured those words against the intent of the statute taken as a whole and concluded that the framers did not intend that law to be, the enactment of that law to be purely optional with the legislature, and there was no Clean Elections Law prior to the enactment of that law. So if the legislature did not appropriate funds to implement it, it would not be implemented. And by the time the Bates case came before this court, certain candidates, at least one, and I think in the course of the litigation another, had qualified for funds under the Clean Elections Law, so it was clear exactly how much money would need to be appropriated to enact that law with respect to those candidates. I would agree with Mr. Cordy's assertion that this law, if enacted, would require the legislature to fund the ABCC sufficiently to enact it, but I do disagree that it would be required to spend any particular amount of money.
Okay. Thank you.
Thank you.
Justice Gaziano.
No questions. Thank you.
Thank you.
Justice Slowey.
Sure. So, as Justice Budd alluded to, you can take almost any situation and find relatedness at a certain level. And perhaps the relatedness here is that people are really busy or they're lazy and they just want to go one place, be able to get beer or wine. Just like some people, they want to be able to have all options where and how they get their newspaper. But what if that person who really just wants to be able to buy beer and wine wherever he or she may be, really doesn't like the idea of having this concentration of business in a few hands, or doesn't like to go to the local liquor store where they also sell prepared food, doesn't want to every single day stand in line in front of the people that he or she sees every day and show their ID. Don't you have a situation where you've got a voter who, yes, on a level, you've got relatedness as it relates to how the alcohol industry is regulated, but you've at least two other things that are really going to bother voters, and they don't know how to vote because they don't want to vote yes and they don't want to vote no.
Yes, Your Honor. anytime you have a multi-part petition, which is expressly allowed under Article 48, you may have some voters who feel one way about part of it and another way about another part of it. As this court concluded in Hensley, just as we do when we choose candidates, we need to wrestle with what we like and don't like about any particular measure that's before us. The relatedness requirement is not intended to reduce the need to think cautiously about how you feel about a measure, but is rather intended to ensure that voters aren't asked unfairly to engage in that wrestling process. As this court concluded in Dunn, a petitioner can use multiple paths to get to a similar place. In this case, that's what the measure does. It expands availability by both lifting the statewide cap and introducing a new form of license that would not be subject to the local quotas. So we can speculate until the election what might motivate one voter and not another voter, but there is nothing in Article 48 that precludes voters having to review the materials that are before them and make a decision overall how they feel about a particular question.
Well, I guess it's just as Bud was asking where the line is. If you look at Carney and you say, gee, this petition seems to be protecting dogs because you don't have parimutuel dog racing anymore, and the penalties being cruel to dogs have increased, but we found no relatedness there. So the question is that what's the principle, the core principle that you would point to for us to be able to find that line?
The way, Your Honor, that I find it easiest to evaluate these provisions and to harmonize this court's cases is to think about these petitions in terms of scope. And if you can conceive of a scope that will include all provisions of the proposed law and is not unduly broad, then that is one way of arriving at a conclusion that the relatedness requirement is met. In Carney, the court concluded that protection of dogs was simply too broad and abstract. In Gray, the court concluded that education was simply too broad and related only abstractly. In MTA, the court concluded that state and local taxation is sufficiently narrow, and in Hensley, the court concluded that the marijuana, the comprehensive scheme to regulate medical and recreational marijuana was sufficiently narrow. In Hensley, we talked about the provision there dealt with multiple sectors of a retail market, both vertically in terms of cultivation, testing, and distribution, as well as horizontally in terms of on-premises and off-premises retail sales and recreational sales and medical sales. And the court concluded that was not a scope that was overly broad. Certainly this petition that deals with one sector of the off-premises alcohol market, or one sector of the retail alcohol market, is narrower than that. Thank you. No further questions.
Justice Budd.
I have no questions.
Thank you.
Justice Seifer.
Thank you. I just would like to go back for a minute to your answer regarding the appropriation question and the requirement in the petition that there be money, set aside, collected and set aside. But then you say that the legislature would have to spend something, but wouldn't necessarily have to spend all of it. Can you explain? Maybe I just don't understand your answer to that.
Yes, Your Honor. In the Mazzoni case and in other cases, the court has wrestled with the argument about whether setting money aside in a particular fund constitutes an appropriation for purposes of the Article 48 exclusion. And the court has consistently held that no, it does not. The court has not concluded that a measure contains a prohibited specific appropriation, except where the legislature would be powerless to use that money for anything else. In the 1937 opinion the money would have gone to the legislature to the executive branch without any action by the legislature. And in the law at issue in SLAMA, the money would have been distributed to municipalities automatically and without further appropriation. So the subject to appropriation language, as this court has developed its jurisprudence in this area, means that the legislature retains full spending authority. Under Mazzoni and other cases, it is just simply not the case that assigning money to a particular fund removes it from the control of the legislature. It doesn't. So while it is true that the legislature would need to either sufficiently fund this initiative petition to implement it or choose to repeal it, it would not be required to spend any particular amount of money to do that.
Okay, thank you. No more questions.
Justice Kafker.
So I just want to make sure, are these the subject to appropriation as justice? Are subject to appropriation magic words then? As long as they're included, our analysis ends?
I would not call them magic words because I think that is making light of a very serious.
We can quibble over the terminology, but I'd like to understand, if that language is included, does our analysis end?
Unless this court were to reverse its positions in AIM and Gilligan and Mazzoni, yes.
Okay, so that's the end. We can stop worrying about that one, in your view. The second point, it's related to Justice Budd's question about just sort of relatedness, and I'm struggling with the Gray case, particularly. So in Gray, it's the course, we create a course, subject matter, but then we don't allow testing on it because we decide that's unrelated. But isn't that almost exactly like what we're doing here, which is we're opening up the number of licenses, but we're saying, okay, but that means we've got to have better identification at the checkout counter. I don't understand how we can reconcile Gray with this case.
Well, as Your Honor knows, I certainly made arguments in favor of a conclusion that the petition at issue in Gray was related. But in fact, this court disagreed, and I think this court's ruling there does not compel a different result here. The court in Gray concluded that there was no operational relatedness between the MCAS question release provisions and the other provisions in the law that would have ended the Common Core requirements and provided a path for adopting new curriculum frameworks because the MCAS question release would occur regardless of what frameworks were in place. In Oberle's, and I think as well as here, the petition that was certified by the Attorney General, and that certification was upheld by this court, the court concluded that the provisions were operationally related where the patient-nurse ratios were to be implemented in a particular way that would preclude certain employment from being terminated. Here as well, if I own a chain of grocery stores and I currently am unable to apply for a license in my particular town, either because of the quota for Section 15 licenses has been reached, or because I already hold 9 licenses statewide, and this law is enacted and I am permitted to apply for that license, and I am lucky enough to receive that license, the other provisions of this law will govern how that license is implemented, both in terms of ID requirements and hiring and funding the ABCC inspectors who are going to come in and inspect my business. So every provision of this proposed law is operationally related. That was not the case in Gray, as this court concluded.
Okay, I'm all set. Thank you.
Thank you.
Chief Justice Gantz, I've got questions. With regard to the fund that is created, is this the first case in which we've ever which initiative has created a fund which pulls money from the general fund and puts it into a new fund, as opposed to simply saying the initiative will generate new revenues which will be placed in a special fund?
I believe in Mazzoni there were new revenues, but there was also a redirection of existing revenues. It may be the first time that the redirection of revenue is not coupled with the creation of new revenue. But the setting aside of the revenue should not, under this court's precedence, make a difference in terms of specific appropriation question.
Okay, put aside. I'm not troubled by whether it's a specific appropriation. The question, I guess, is whether or not this goes to the issue of whether it's related. So they put 90, let's assume this passes,
yes,
$90 to $100 million of excise taxes that come from the sale of alcohol, which right now are going into the general fund, would go into this special fund. Let's assume the legislature appropriates only $20 million to ABCC, but let's also assume, which I think we can certainly assume, that the legislature is going to be strapped for money next fiscal year, and is going to say, we want to spend this money on school food. So we've appropriated $2 billion to schools, and we're just going to direct the treasurer to take the rest of the money made from this fund and spend it on schools. Can that be done without special legislative act? Can the treasurer simply say, I'm going to take some money from the general fund, I'm going to take some money from this fund, or does the treasurer need special legislation in order to do that?
The treasurer doesn't need special legislation, Your Honor, but the legislature would have to make appropriation in the General Appropriations Act or a Special Appropriations Act, just like with any other kind of revenue.
Meaning that it would have to say that X amount of dollars out of this particular fund are to be going to schools.
Correct, Your Honor.
I'm sorry, go ahead.
I was going to say there are certain funds listed in General Law Chapter 29 that the executive can access without independent legislative action. They say right in the text, without further appropriation, these funds will be available. If this proposed law had proposed a fund worded that way, I would agree that it would be an illegal specific appropriation under Article 48, but that's not what this does.
So what is the practical consequence of having a fund? Sounds like there's none, according to you.
Under Mazzoni and other cases, it's really just a bookkeeping mechanism.
Without practical consequence?
There is practical consequence in the sense that that is how the money is tracked, and we will then know. But because the law as written leaves the budgetary discretion with the legislature, that doesn't restrict the legislature's discretion at all.
Okay. Let me turn to another question. You heard my hype, and I think you agree that would certainly, if you agreed that this passes muster, you would agree that hypothetical initiative would pass muster.
Yes, Your Honor.
Now, you said that this will affect, say, Total Wine, because Total Wine now, which may be limited to X number of stores in the Commonwealth for the sale of liquor, not merely beer and wine, will now be able to open up however many stores it wishes to sell liquor, correct?
Well, subject to the grant of licenses by localities, yes.
Okay, but the state limitation on, say, Total Wine, I don't mean to pick them, but they have the largest, would be gone.
Correct, Your Honor.
With regard to the sale of liquor.
Correct, Your Honor.
And how is that related to allowing food stores to sell beer and wine?
It's related, Your Honor, because as in done, the drafters here chose two paths to get to the same result, which was increased availability of beer and wine at grocery stores and convenience stores. It is within the drafters' prerogative to conclude that it would be administratively difficult and maybe somewhat dissonant to lift the statewide cap only for total wine. Only for excluding total wine from the lifting of the statewide cap. And in fact, they may have been drafting with a view toward some type of equal protection challenge to the law if it's enacted down the line. So the fact that the statewide cap would no longer apply to total wine, it would mean that, yes, that an entity like that sells only alcohol would have the benefit, but the growth would not necessarily be as fast as growth for these new these grocery stores and convenience stores that would have the benefit of the availability of licenses outside the local quota system. The total wine model would still be subject to the local quota system.
Okay, but certainly you're not saying that the initiative could not have said we're going to drop the statewide cap sale of beer and wine, but we're not listing statewide cap on the sale of liquor.
As a certification matter under Article 48, no, that would not be problematic.
And similarly, with regard to the ID, I understand why you'd want to ensure the showing of an ID at a food store, but is it related that they're now requiring package stores to have IDs where before that was not done? How is that related to the addition of food stores selling beer and wine?
Well, Your Honor, I think that it is, again, within the drafters' prerogative to not choose to propose a law that would set up differing enforcement requirements at different types of outlets for the sale of alcoholic beverages, and to impose. Right now, I think many people might be surprised to know that there actually is no requirement that anyone show an ID when purchasing alcohol. The framers here might have concluded that that is somewhat of an outdated mechanism and not sufficient to keep up with increased availability. The amicus brief filed by Cumberland Farms and their trade organization made reference to a 2017 task force report that the ABCC or the treasurer had convened, and increase or standardizing ID requirements, including with the use of technology, was one of the recommendations of that task force report. It's not unreasonable for the drafters here to conclude that it will be an easier administration of the new law to have those requirements apply across the board. And there is nothing in Article 48 that requires the creation of either multiple enforcement entities or multiple standards in the enforcement of Chapter 138.
Now, you earlier used the term unduly broad with regard to the relatedness issues. When does the scope of the initiative in terms of reaching beyond the sale of beer and wine at food stores become unduly broad? I mean, Mr. Corey has said, well, it's unduly broad in that it goes beyond. It now means that package stores must check ID. It's unduly broad in that it now means there's no cap sale of liquor. It's unduly broad in that it is now putting all alcohol excise taxes into a separate fund. Why is this not unduly broad, given that a narrower scope is certainly possible?
A narrower scope is certainly possible, Your Honor, and a broader scope would be possible as well. If this proposal were to I think it would still fall within this court's cases on a legitimately related and narrow scope if this law were to propose changes in the entire alcohol distribution scheme under Chapter 138. The sale of alcohol, both in restaurants and in for off-premises consumption, is certainly not broader than the law that was approved by this court in Hensley. I think the limit for what is too broad a scope has got to be someplace in between education, as in Gray, and state and local taxation, as in MTA. But I think you could completely revamp Chapter 138 with respect to the sale of alcoholic beverages without creating a scope that's unduly broad under this court's cases.
I have no further questions. Are there any additional questions from my justice colleagues?
No, thank you.
And hearing none, that will close this argument. I thank counsel, and I thank my fellow justices. Thank you.
Thank you very much.